Alors, bonjour à tous et à toutes.
Hello, everyone. This meeting is now open. Welcome to meeting number 84 of the Standing Committee on Industry and Technology. Today's meeting is taking place in a hybrid format, pursuant to the standing orders. Pursuant to the order of reference of Monday, April 17, 2023, the committee is resuming consideration of Bill C-34, an act to amend the Investment Canada Act. A reminder that all comments should be addressed through the chair. For the safety of our interpreters, please ensure that you speak into the same microphone as that which your headset is plugged into. I'd like to welcome back to our witnesses. We have Mark Shan, Senior Assistant Deputy Minister, Strategy Innovation Policy Sector, Jameson McKay, Director General, Investment Review Branch. We also have with us James Byrne, Senior Director, Investment Review Branch, and Mehmet Carmen, Senior Policy Analyst, Investment Review Branch. I hope that you all had a wonderful summer. It's a pleasure to see you all again. And I would like to wish a welcome to Ryan Turnbull, Parliamentary Secretary, joining us at the committee.
I hope they last the whole session, but hopefully. But it's off to a good start, so thank you for that, colleagues. And before we get back to C-34, I know that there are some study motions that some of you want to table, so we'll get that out of the way, and then we'll resume with C-34. So I yield the floor to Mr. Perkins.
Thank you, Mr. Chair. Welcome back. And Mr. Turnbull, welcome to the committee. And officials, good to see you again. I'm sure you missed us over the summer.
They're ready for a filibuster.
They're ready for a filibuster, yeah. This is Finance Committee. Anyway, I have a study motion to move, and I think Mr. Viss will move the other one. So I'll just get right to it. I think the clerk has just distributed them. I understand we'll debate and discuss them once we're through 34, so thus won't delay clause by clause. So I move that, pursuant to Standing Order 1082, the committee invite the Parliamentary Budget Officer to appear for 2 hours to address the report, brackets, break-even analysis of production subsidies for Stellantis, LGES, and Volkswagen.
Thank you, Mr. Perkins. So as you mentioned, if all agree, we'll get back to it at the end of the meeting. So that motion's been tabled. Mr. Viss.
Well, thank you, Mr. Chair, and to my colleagues. Happy to be back. I'd like to move, pursuant to Standing Order 1082, the committee order the Department of Innovation, Science and Economic Development Canada to release a redacted copy of the Strategic Innovation Fund contracts with Volkswagen and Stellantis to build a battery plant in Windsor and St. Thomas, Ontario, in order to understand the contract that was agreed upon by both parties, and that such release be given to the committee via email no later than October 3rd, 2023, and that no speaking restrictions be placed on committee members with regard to said contract.
Thank you very much, Mr. Viss. Je reconnais Monsieur Lemire.
Mr. Lemire. Thank you. Thank you, Mr. Chair, and welcome, everyone. More specifically, Mr. Turnbull. And hopefully that will keep this a collaborative mood, because I think we'll have a very busy fall. I would like to table this motion for a study before the committee, study on modernization of the regulatory framework of wireless products, according to 182, that we have a study on the modernization of the regulatory framework and convergence of cabled and wireless, and that solid recommendations be made for all the consumers in terms of access and affordability, that this convergence be examined with the appropriate actors of what is possible through technological advancements, such as fiber optic, Wi-Fi 6, and others, that they examine the need that they examine necessary speeds and innovations for businesses and consumers in Canada and internationally, that they examine the operational costs of these technology and maintenance of infrastructures, critical infrastructure, that more specifically we look at the non-used spectrum in rural and isolated areas, that we examine telecommunications towers and the deployment of infrastructure, that the committee has 6 hours and that they report to the House. The interpreter is sorry, but I do not have a copy of this.
And has, Monsieur Lemire, est-ce que ça a été circulé par
Non, elle n'a
qui,
pas circulé.
No, it wasn't sent out, but I don't think it will be debated today necessarily. If that's the case, we can send it. Great, thank you. If you'll allow me, I have a second one on the sale of future electronics, according to 182, that the committee undertake a study on the sale of future electronics and that it bring its conclusions and recommendations before the House.
Monsieur Lemire, oui, je vois Monsieur.
Thank you, Mr. Lemire. I see Mr. Viss.
When I read out my notice of motion, I realized that it could be misinterpreted. I only mentioned the SIF contracts, but I was also alluding to the production contracts. There's actually 2 contracts. There's actually 4 contracts in question. And the spirit of the motion is that we see all 4 contracts. Thank you.
Thank you, Mr. Viss. Understood. Mr. Massey.
Yeah, thank you, Mr. Chair. I was wondering whether we're going to have a maybe a subcommittee meeting or, looking at what legislation is going to come forth and so forth. I mean, some of these motions are excellent. Actually, they're all really good motions. I mean, in different ways. I have amendments to them. But at any rate, I'm just wondering whether we're going to have our own kind of planning meeting, because it'd be interesting to find out, like, also too, where C27 stands as we're working through this. Obviously the one by Mr. Perkins with regards to, the PBO officer was just like one meeting. So that's easy to deal with and dispense. But the other suggestions are fairly more comprehensive and would require planning. So just throw that out there, kind of where maybe you can share with us where you think, how'd you like to deal with this? Or if we are going to go one-off at them at the end of the meeting if there's time, or maybe Thursday if we get through 34 today or whatever, or next week. Anyway.
Yes, just to provide a bit of context, the idea for Thursday's meeting, and I'm hopeful that we'll get C34 done and we can free our friends who've been in with us already many meetings. Then Thursday would be a steering committee meeting so that we can hash out the plan, in particular with regards to C27, how we intend to approach it, and also perhaps, depending on which motions, if we have time to vote on some of the motions that have been presented, how we intend to deal with them.
Okay.
So Thursday that would be, though I hear there might be some, we might get canceled on Thursday because of the state visit, so it's Friday? Okay.
Yeah.
Okay, so then we won't be most likely, and Mr. Perkins is, they don't tell me anything, They tell everything to Mr. Perkins.
He's a wily guy.
So we'll have the chance then on Thursday with the steering committee to look into it.
Nobody knows the bubble of Ottawa better than Mr. Perkins.
See, we're privileged to have him on this committee then. So without further ado, let's get back to C34. And as you might recall, colleagues, we were at new clause 8.1 and the NDP 2 proposal, which is referenced 1254963. Le paquet, which is at page 4.1 of your package.
Mr. Chair, I'd like to speak to that as well.
Yes, so I recognize Mr. Viss and then Mr. Gahir.
Well, thank you. In respect to clause 8.1, I'd like to move a sub-amendment which reads as follows: the effect of the investment on privacy interests, comma, including comma, without limiting the generality of the foregoing comma, on the use and protection of personal information about Canadians, semicolon. The effect of the investment on intellectual property interests, including comma, without limiting the generality of the foregoing comma, on rights relating to intellectual property whose development has been funded in whole or in part by the Government of Canada. And during committee meetings, government officials warn members that listing individual factors and considering a net benefit review could potentially create the adverse effect of disallowing additional factors from being considered that aren't listed in the bill when conducting a net benefit review. This amendment seeks to address those concerns by broadening the examples covered under this section even if they are not specifically listed as examples. Doing so will ensure that issues not listed under Section 20 of the ICA are still considered when conducting a net benefit review, while also guaranteeing that both IP development and Canadian privacy are factors considered. This was done in good faith to the NDP amendment to make sure that we could see the spirit of Mr. Massey's amendment pass with those concerns addressed. Thank you.
OK, donc on en est à débattre le sous.
So we're debating Mr. Viz's sub-amendment, amendment to NDP 2. Mr. Massey.
For giving me this in advance, and I see this as a friendly amendment to what we're trying to get, and thank my colleagues for providing that to me in advance. And I don't have any further questions. I think Mr. Viss has explained the sub-amendment and really the amendment itself very well. So, thank you.
OK, j'ai Monsieur Gaillard.
Thank you, Chair. And through you, so we've had a summer, obviously, since we last debated this. I'd like to just get the expert's view on what the original amendment does and what Mr. Viss's sub-amendment does to it.
Monsieur Chan.
Merci, Monsieur Président. Thank you, members. If I understand the sub-amendment correctly, I think one of our concerns prior to the summer break was not to give the false impression or to potentially confuse the situation that something that is already able to be considered is actually able to be considered. And so there's two thoughts that are kind of present that I see within the context of the sub-amendment. It is helpful in that it suggests that it's not without prejudice to the foregoing, as in it broadens the consideration. The contention, though, is that the consideration of privacy matters and of intellectual property matters are already factors that are eligible for consideration under net benefit reviews. And so it's less of a concern about whether or not it's only privacy and intellectual property because we've listed them, but actually that we might be undoing the generality of the current provisions that actually suggest that these are already reviewable factors. And so I think there had been some consideration prior to the break whether or not a for greater certainty clause could be clear that these are including but not limited to. And so I think that was the spirit with which this was potentially understood.
Merci. Monsieur Gaillard, voulez-vous...
Mr. Gaillard?
Isn't a question of inadmissibility in regards to this amendment and sub-amendment?
I can't speak to the inadmissibility. I think there had been some consideration as to whether or not a further sub-amendment would actually simply make it very clear that that these are factors that were not necessarily precluded from consideration, but could include or already do include these issues.
Mr. Massey.
Yeah, thanks. Mr. Chair, and yes, there was that discussion on it. That's correct. So, and again, that's complementary, I think, to it. Without revisiting the whole debate, it was about those two issues becoming more dynamic in their current laws, and so we wanted to reinforce, touching on them, and we don't want to do it at prejudice something else. So I'm supportive of both of those initiatives.
Thank you very much, Mr. Massey. Monsieur Lemire.
Oui, j'aurais une question à savoir.
I'd have a question. I'm trying to see how this ties in with the Americans and their IRA, their Inflation Reduction Act. How do we tie both? Is Canada penalized? So, if I've understood the question, Mr. Chair, the role of the IRA in the U.S. includes measures that provide support, but I'm not sure if there's a direct link between this proposal and the IRA. Well, the idea is to make sure that these protectionist measures that were brought forth, there were negotiations with the Biden government and the U.S. Does this type of amendment hinder competition or protection of private information in Canada? Thank you, Mr. Chair, for the question. So it's hard to provide a direct answer because I'm not sure of the direct implications with the U.S., but right now, in the Investment Act, protection of data will be considered, and there's no issue with the U.S. The U.S. also has their own legislation with regards to the protection of personal information and business information. Thank you. Thank you. Any other comments on the sub-amendment before going to a vote? Mr. Turnbull.
Ask for clarification from Mr. Sean, whether your comments imply that this sub-amendment would undermine the general nature of the net benefit review, and is that how I'm understanding it? Am I understanding correctly?
Yes. Our concern prior to the summer recess was that such a clause, by giving, to use colloquial terms, like a shout out to privacy and intellectual property, might suggest that intellectual property and privacy aren't currently factors under consideration of the net benefit review, when very much in our understanding and in our readout they are. And so in many ways, I think our goal would be to see a sub-amendment that would assure those reading this that the imposition or the introduction of these two factors aren't at the expense of the consideration that they were already there and factors for consideration under the net benefit review.
No more comments. So then we'll move this sub-amendment presented by Mr. Viss, which you've all received to a vote. So, Madame la Greffière.
Mr. Turnbull.
Against.
Mr. Sorbara.
Against, please.
Mr. Gahir.
Against.
Madame Lapointe.
Contre.
Mr. Van Bynen.
Against.
Monsieur Généreux.
Pour.
Mr. Perkins.
For.
Mr. Viss.
For.
Mr. Williams.
For.
Monsieur Lemire.
Contre.
Mr. Massé.
Alors, le sous-amendement est...
The sub-amendment does not carry. This brings us back to NDP 2, which is section is 8.1. Mr. Massé?
Yeah, so we went through this dance before with regards to it, and there actually was kind of an agreement with the Liberals actually to do it. So it's pretty shocking to start this way because that was actually the understanding. And we went through a lot of talk and testimony, and what we heard in terms of the response was kind of really the false straw man argument about somebody reading legislatively through this, and it actually isn't based upon any really substance of anything than just a impression of what may or may happen. It's a boogeyman argument that we've been getting. I'm not going to revisit all that, but I just have to say I'm pretty disappointed because we had actually reached a common agreement on this, and apparently that's torn up.
Thank you, Mr. Massé. Mr. Gaillard.
So we recognize that we had sort of reached an informal sort of agreement. So we would ask the clerk to circulate the new version of the amendment, which it should be in your email already. And I'd like to move a sub-amendment.
Okay, the sub-amendment.
Yeah, exactly, a new sub-amendment. And I think that should achieve what Mr. Massey is looking for. It'll be our compromise to make sure that we're not undermining the general nature of net benefit review.
So I understand that you're moving the sub-amendment
Yep.
that was circulated via the clerk.
Yes,
So
just now.
Is there a paper copy, Mr. Gaillard? Is there a paper copy, Mr. Gaillard,
Yep.
for members? Well, I believe it was circulated via email to all members of the industry committee this morning. Was it not? So the sub-amendment proposed by Mr. Gaillier was circulated, but will be circulated by the clerk again via email so that all members can see it. And I'll give just maybe a minute or two for members to consider it before we can start debate on it. Okay, I'll just briefly, colleagues, I will suspend for 2 minutes just for the sub-amendment to reach everybody's mailbox. So meeting suspended for 2 minutes. Been received by everyone and circulated by the clerk, so we can resume this meeting. So the sub-amendment Lib 01 then is proposed by Mr. Gaillier, and it's up for debate if there are any comments. Otherwise, I'll move it to a vote. Just wondering, yes, Mr. Turnbull.
Question for clarification. Was this circulated on June 21st?
I believe it was. I haven't verified if there was any change
So
to the
the
language.
stuff we've been hearing, the comments were not actually accurate, that this actually was circulated on June 21st.
I believe it was Mr. Turnbull, but
I'll get evidence of that just so we don't have to...
Mr. Massey, but it was circulated also today, this morning, and today, but I believe it might be a slightly different version. I'm not sure. Mr. Massey.
Amendment. I'm not going to support this because it'd be just like hypocrisy for myself, and I'll let them have the amendment. I mean, it's ridiculous, really, what's happening here, and it's unfortunate. We had all summer to work on this. There was an agreement. We worked on a lot of these amendments in good faith. I even dropped out some amendments that the government had as they were uncomfortable with on a few different things. And it's funny because, you know, I've been in touch with ministers all over the summer, some of them coming to do fundraisers in my riding, others to actually come and meet with me. Variety of opportunities that this could have been brought up at least as something. And it's disappointing because this committee actually, you know, has a history of working together and actually living up to its word. And so everybody has a right to drop an amendment or sub-amendment at any point in time, but there's generally a piece of courtesy involved. In fact, actually, I voted for some Liberal sub-amendments related to this because that was the deal, was I was supposed to get my amendment passed, and the concerns that were raised are really nothing more than basically straw men with regards to the concerns on my amendment. And so pretty shocking and surprising that we want to start this way, but if that's the case, then fair enough. And maybe perhaps it's just because somebody wants to have their own name on an amendment. I don't know. But it's a pretty significant double cross when you think about it, especially given the history of what took place in supporting the other Liberal amendments that we did change during this legislation. So sadly, we start this way, but that's okay.
Thank you, Mr. Massey. Mr. Gaillard.
No, I'd like to communicate to my colleague, who I respect a lot, and I've served on this committee with him for 2 years, and I know he has a lot more experience on this committee than me, but this is not a slight to him. This is not a slight to his amendment. We're just introducing a little bit more certainty, and this committee has debated individual words within amendments. So I don't see what I've done that's wrong here. And again, this should have been circulated, I think, June 21st. And it was circulated again this morning. Again, this achieves the purpose that the member is looking for. So I don't think there needs to be much debate. We're just clarifying language.
Thank you, Mr. Gaillard. Mr. Perkins.
Let's say I'll be voting against this simply because the Liberals voted against essentially the same amendment just a few moments ago with the addition of 3 words, which basically at the time the officials in reviewing ours said it provides the greater certainty, greater clarity that it wants. But the Liberals chose to vote against it for the purpose of putting in their own motion that does essentially the same thing. So goose and gander sort of thing.
Okay, if there are no more comments on this, we are voting just to be sure on the sub-amendment proposed by Mr. Gaillard, referenced 125-46585. That was circulated to members via email. So, well, this is the one I just received. Just one sec.
Not in our emails.
No.
It says that, but I'm on June 19th, and it didn't arrive. It didn't arrive June 21st.
It's different.
Just 1 second to make sure that we have the right reference number for the amendments that we're voting on, because the one I've just received from... Okay, just 1 second. So, Mr. Gaillard, just to be sure, is this the correct version, the one that was sent by the clerk? So, reference number 125-46585.
That's correct.
That's correct. Okay. So, if it's clear to all, I'll ask the clerk to proceed to a vote.
Mr. Turnbull.
4.
Mr. Sorbera.
Un favor.
Mr. Kahir.
4.
Madame Lapointe.
Pour.
Mr. Van Bynen.
4.
Monsieur Généreux.
Contre.
Mr. Perkins.
Against.
Mr. Viss. Mr. Williams.
No.
Monsieur Lemire.
Pour.
Mr. Massey. 5, 6 pour, 5 against.
So 6 in favor, 5 against. The sub-amendment is accepted, ce qui nous ramène à NPD.
NDP 2 with a sub-amendment. Any comments before going to the vote on NDP 2?
S'il n'y a pas de commentaires,
If there are no comments, we'll put this to a vote. NDP 2 with a sub-amendment by Mr. Gaillard, sub-amendment that we've just voted on. Madam Clerk.
4.
Mr. Sorbera,
4.
Mr. Gaillard,
4.
Madame Lapointe,
Pour.
Mr. Van Buyden,
4.
Mr. Genereux,
4.
Mr. Perkins,
4.
Mr. Viss,
4.
Mr. Williams,
4.
Mr. Lemire,
Pour.
Mr. Massey. 4.
donc l'amendement
NDP 2 is carried as amended.
Mr. Perkins.
I've just done a quick review of the package that was sent in late June of amendments for the committee, and I don't see this amendment in that unless I'm missing it. Who is it from? Because I've gone through it. And Mr. Turnbull said it was circulated then, and I don't see it. So
Okay, we can, the sub-amendment was properly presented, Mr. Perkins, and distributed. We can do a forensics to look at the exact date when it was first submitted, but I'm not sure that it's a useful use of committee time, so we'll leave it at that if you don't mind, and move on to CPC 5 on clause 12. Mr. Perkins.
thank you. Just want to get my paperwork here. CPC 5. So Bill C-34 doesn't do anything to trigger a national security review when purchases of strategic assets are made, such as IP data, mines, land, machinery, separate from the actual company itself. The current amendment seeks to expand the application of what constitutes an investment that is injurious to national security by expanding the application of a national security review to any acquisitions of an asset made by an SOE of a Canadian business. While Bill C-34 allows for the minister to conduct a national security review of acquisitions by non-Canadian companies, the bill does nothing to trigger a security review when strategic assets are purchased by a state-owned enterprise. The concern is supported by much of the evidence presented at INDU during the committee study and the witnesses during this bill. For instance, Jim Basili recommended that the bill should do more to protect assets deemed critical to Canada's security and prosperity by broadening the focus of any review to include assets of strategic technologies and industries.
Okay, so we've all heard the term of the proposed amendment to clause 12 CPC 5. Are there? Yes, Mr. Gahir.
So this amendment, in my reading, expands the jurisdiction of the ICA National Security Review to asset sales by SOEs. Including this amendment could be interpreted as narrowing the scope as it's currently interpreted, but we can ask the experts if they believe so, and I would like to bring forward a sub-amendment.
First, we'll go to our officials for the questions you've just asked, and then you can present your sub-amendment. Mr. Chan.
Merci, Monsieur le Président. Comme je vais...
Thank you. As I had said in June, we have a process with officials that includes the asset acquisition by all Canadian businesses.
Interpretation and continuation of the implementation of the Act, that the study and application of the Act to asset sales is already contemplated. And so I think our discussion in June was that this should be, again, would be helpfully clarified if it noted that this was, in fact, already within the jurisdiction of the Act, because we've actually taken cases with this very kind of use case in mind.
Thank you. Mr. Gahir still has the floor, Mr. Perkins, but I see you Just a question for the officials? Okay, I'll, if you don't mind, Mr. Gaillard. Yes, Mr. Perkins.
Thank you, Mr. Chair. Just to clarify, where in the Act does it say that asset sales are reviewable? In the Act, not in policy or regulation?
So as it was described in June, the outline of what is reviewable under the Act is already determined to be set out in factors that are quite wide to allow for a wide array. And so you won't find specific references to particular technological terms or aspects, in part be to allow for the continuation of the Act to apply in a whole host of use cases, including to those of asset sales. As I've indicated, we actually have proceeded in this domain, and it is our view, not only our view, but it has been our action that actually the Act already applies in this particular zone. And so we would just want to make sure that this call out to this important aspect isn't actually at the cost of suggesting that it wasn't there before.
So this is another suspenders in a belt one that we talked about, that we want for greater certainty, to use words from the previous motion, that it actually be in the Act.
I realize our drafting conventions are annoying, but we just want to make sure that we've preserved our capacities.
Okay, yes, Mr. Gaillard.
Sure, thank you. I'm asking for a brief pause. There seems to be a little bit of confusion about what's been circulated, what's not, and I'd like to speak to my colleagues as well, so asking for a brief pause.
Okay. There's just one sec. Okay. Given that we've had 2 months away from the House and from the joys of C-34, I will grant a very short pause because I believe some of these discussions could have happened before the committee. So I'll briefly suspend for 2 minutes. I knew it. Okay, colleagues. Colleagues, we're going to resume, please. So we were at on clause 12. I hope the confusion is dissipated and we're all on the same page. We were at CPC 5 on clause 12. Are there any more discussions on CPC 5? Mr. Perkins.
Well, and I don't know if this is order, but thank you, MP Turnbull, for the clarification. But this is the part I'm not sure if it's in order. I know there's another amendment coming in the same area, and just in the consideration of whether it should be this one or the next one, my non-lawyer reading of that is that it actually is a narrowing of it because it's saying it has to be significant assets of a corporation, not just assets, but as substantially all of the assets, which is very different than the one that we've got. And to me, based on what Mr. Shen said, it actually would be a narrowing over what exists in the Act. But I'm not a lawyer.
I don't know if Mr. Shen wanted to intervene, and then we'll move it to a vote.
So once the word assets is in one of these amendments, including substantial assets, it would allow for guidance to be able to issue as to what that means. The problem with any asset is if I sell a photocopier and I run a laser business, I potentially am now encumbered by the Act because I'm actually selling an asset. And the asset may or may not be substantive to the operations of the business. And so there are both resource implications in terms of the number of company and asset transactions that are suddenly within our purview of review, and then also the degree to which we have the capacity to be able to actually issue guidance. And so the rationale for this determination is for us to be able to issue guidance to ensure that actually what we're getting at is meaningful.
Mr. Viss.
Well, just in response to that, it's important to understand that it's only applying to state-owned enterprises, and the scope of companies in Canada that state-owned enterprises would be interested in acquiring is in fact very narrow. So we're not applying to general commerce here. We're only applying to state-owned enterprises, which already narrows the applicability of this clause in the first place. So I would kindly disagree with your assessment there. Thank you.
It's on the record. Thank you, Mr. Viss. Are there any more comments on CPC 5? Otherwise, I would ask Madam Clerk to move it to a vote.
Mr. Turnbull.
In favor.
Mr. Sorbera.
En favor, s'il vous plaît.
Mr. Gahir.
In favor?
Madame Lapointe. Pour. Mr. Van Bynen.
For.
Monsieur Généreux.
Oui.
Mr. Perkins.
Yes.
Mr. Viss. Yes. Mr. Williams.
Yes.
Mr. Lemire. Mr. Massey. Tout le monde en faveur.
Oui, donc c'est l'unanimité. L'amendement
CPC 5 carries unanimously. Now, CPC 6. On page 8 of your package.
6 is up next, and I will yield the floor to Mr. Perkins, I assume. Mr. Perkins.
Merci, Monsieur Chair. My French is so good.
You were in Quebec City not too long ago.
I was last week. Bill C-34 doesn't trigger a national security. Sorry, I'm reading the wrong one. That's the last one. Okay. Yeah. Make sure I got the right one here. Yeah. So their C-34 does not provide exceptions for the national security review for allies, Canadian allies. So the rationale is that several witnesses expressed concerns that national security review process could harm legitimate foreign direct investments, specifically witnesses like, and I'm probably going to butcher this name, Sabruta Bhattacharjee highlighted the impact of an overly broad review process that could have on holding up important acquisitions and could potentially scare off legitimate investors. The concern becomes more prevalent if some of our other amendments succeed, specifically some of those that sought to broaden the national security review process. Because Canada's national security interests are aligned with members of the Five Eye Intelligence Alliance, there is no need to impose additional regulatory burdens on allied state-owned enterprises for purposes of national security. Further, consideration should be given to the considerable economic ties between Canada and its allies and the impact the review process could have on trade. In light of these concerns, this amendment seeks to provide an exemption to national security review processes for state-owned enterprises from the Five Eyes Intelligence Alliance countries.
Okay, thank you, Mr. Perkins. So I have Mr. Turnbull on CPC 6.
I just had a couple of questions for the officials. Mr. Champ, do you think that this amendment introduces differential treatment that could lead to legal challenges? I'm also interested in how this might impact our trade agreements and relationships and whether you think it's necessary at all.
Merci, Monsieur le Président, pour la question.
Thank you for the question.
Our assessment in reading through the amendment is that this could very much be reviewed and understood to be differential treatment, in that it does favor and provide differential treatment between some people for whom we have trade agreements and not others for whom we have trade agreements, and that would likely be contemplated as offside of our most favored nation clauses that are in the vast majority of our trade agreements, as is with respect to its utility, I think we already do ensure that national security reviews are important and considered in all cases, but in cases for which there is no clear raising of questions related to national security, that they not be an encumbrance to the investment climate in Canada.
Me? Yes. You want?
Suspend for just a moment?
I've granted it for, yeah, okay. We'll suspend for 1 minute because I've accepted on one side, I'll accept on the other side. Mr. Perkins on CPC 6.
How often I'm presuming you're referring mainly to the WTO? And in these various trade ruling bodies, how often have we been challenged in the past for that provision of deferential treatment?
Most favored nation clauses, I wouldn't be able to give an exact number, but they are important clauses that have actually been the subject of a number of trade disputes. I can't speak to how many of them actually have been gone through the entirety of the process, but the most favored nation clause and the assurance that we're actually providing equal treatment to all is an important consideration. I'd also just note that in the vast majority of cases we get, the lead investor and the origin country of the lead investor is not usually the subject of the concern. It's usually a minority relationship that actually exists within the investor company. And so by exempting Five Eyes from national security reviews, you wouldn't want to by some sort of proxy actually suggest that the minority relationships of those countries' investors are somehow not subject to review, because actually those are a huge chunk of the things that we review, is that we've got an ally country investor, but
I get that, except this is specific to state-owned enterprises. So, but the question then is, does the U.S. not do this all the time with most favored nation status?
Differential treatment?
Yeah.
I certainly wouldn't want to pass judgment on the status of U.S. law, but I would indicate that there are considerable concerns in the international arena about most favored nation.
Thank you.
Okay, are there any more comments on CPC 6? Seeing that there are none, we'll move it to a vote. Madame la Greffière.
Mr. Turnbull.
Against.
Mr. Sorbara.
Contre.
Mr. Gahir.
Against.
Madame Lapointe. Contre. Mr. Van Banen.
Against.
Mr. Genever.
Pour.
Mr. Perkins.
For.
Mr. Viss.
For.
Mr. Williams.
For.
Monsieur Lemire.
Contre.
Mr. Massey.
Donc l'amendement CPC 6.
CPC 6 is rejected. This brings me to Lit 03. You'll find this at page 8.1 of your package. It was presented by Mr. Gahir. Mr. Gahir.
Thank you, Chair. I just want to clarify the reference here so we're all on the same page. The reference is 12542468.
Exactly.
Yep, perfect. This has been circulated, and from what I can tell, this is basically to ensure that when a company is selling, let's say, a photocopier, that they're not subject to these sorts of review. And, you know, for the review part, it includes the acquisition of all or substantially all the assets used in carrying out the entity's operations. So just to clarify that, but I'd like to ask the officials to comment as well.
Yes, as I noted earlier, I think we have the capacity, once the Act contains words related to assets, to ensure that the guidance reflects the intent, which is to look at the sale of assets that are actually meaningful. And notwithstanding contentions, that state-owned enterprises do come from a number of countries and in a number of formats, and I think often may actually potentially have other asset sales that may not meet the threshold of meaningful.
Thank you, Mr. Gahir. Mr. Perkins.
So given my earlier amendment and this one, I just want to clarify, I suspect state-owned enterprises aren't coming to Canada to buy photocopiers. I don't think we manufacture any for that reason, but that would be a different type of thing. That would be a normal procurement thing. What is the definition of when you say substantially all of the assets? Because what we're saying in the previous one that we just passed is assets. In this case, does that mean everything except the shell company, a holding company? If I were a Canadian mining company with a number of mining assets, for example, and I sold one mine to a Chinese state-owned enterprise, that's not substantially all the assets of that mining company. So would it then not be reviewable based on this amendment?
Our contention would be that the modifiers on assets allows for the implication that the Act would be reviewable and would allow for the review of transactions that were meaningful parts of the business. And that would actually include the types of asset sale that you just described. But to suggest that any asset potentially actually would actually potentially stretch into the territory of populating the subset of concern.
So could I propose an amendment to this amendment and remove the words substantially all of the assets and replace them with the wording that Mr. Shen just said, which is meaningful assets?
Can you just repeat Mr. Perkins'
Remove
exact
the words
wording?
substantially all of the assets and replace it with meaningful assets.
So
Now, I'm not a
So-
lawyer, so I don't know if meaningful is a proper legal term.
Includes
But
the-
you, Mr. Shen, just talked about meaningful access. So it's, to me, is very different from the idea of substantially all of the assets.
Yeah, just Mr. Perkins, if you could just, I know you asked a question to the officials, I'll let them collect their thoughts on this, but what you're proposing is under paragraph 1C includes the acquisition of all,
Of meaningful assets instead of all of the substantial
of
assets.
meaningful assets used in carrying on the entity's operation.
Right.
Yeah, I'm not sure that meaningful assets has a legal definition attached to it. But that's the sub-amendment proposed, Mr. Perkins, and
Well, I'm open to a better word to express meaningful. I don't think substantially all gets to the concept that Mr. Shen was talking about. Substantially all means if I have 10 mines and I sell one, that's not substantially all of my assets. It's 10% of my assets.
so, and you had asked the officials for their thought on your proposed sub-amendment.
yeah, whether
we'll wait to
meaningful
hear
is-
from them and see if you want to move that sub-amendment.
Sure.
So I will defer to Mr. Shan if you want to intervene.
I think, Mr. Chair, that I think R for greater certainty would look at an investment to acquire in whole or in part the assets of an entity referred to in the paragraph. And I think that part allows us to get at a proper guidance as opposed to the possibility of meaningful in whole or in part.
Instead of substantially all of the assets, in whole or in part. That would be more proper legal wording than what I was saying.
Yeah.
What do you guys think? Yeah?
So, Mr. Perkins, what then would be your sub-amendment?
Then, based on what the officials said, referring to the amendment, the acquisition of all or whole acquisition of in whole or in part the assets.
Referred to in that paragraph. Yeah.
Okay, I think Mr. Gahir has language he wants to propose.
Can I propose a language based on what's been said? So we can say for clause 2, for greater certainty, paragraph 1C includes an investment to acquire, in whole or in part, the assets of an entity referred to in that paragraph.
Can you just repeat it once more?
I will repeat it once more. So clause 2, for greater certainty, paragraph 1C includes an investment to acquire, in whole or in part, the assets of an entity referred to in that paragraph.
So you're deleting the rest?
Yeah.
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 Yeah. I like that.
Okay, can it?
Do
can
they
it be
like that?
Okay, can it be sent by writing and repeated once more, very slowly, Mr.
I will
Gahir?
repeat it once more. Sorry, I talk really fast.
You talk fast indeed. And for the interpreters also, it's always
Yep.
good to speak slowly.
So clause 2, for greater certainty, comma, paragraph 1C includes an investment to acquire, comma, in whole or in part, comma, the assets of an entity referred to in that paragraph, period.
So you've all heard the terms of the friendly, and it will be sent by writing, Mr. Gahir, to the clerk, please.
Yep, it will be confirmed.
Okay, but we've all heard the sub-amendment, so that's a sub-amendment to your own amendment. Just one sec. So you can't...
I remove mine and I'll... My amendment? You can't amend.
it actually-
Can we propose that as my amendment? Because you can't amend your own amendment.
Yeah, so Mr. Perkins' sub-amendment as outlined by Mr. Gahir.
Perfect.
That's okay. So you've all heard the terms. I believe there's unanimous consent looking around the room. Do I need to move it to a vote, Madam Clerk? No. I see there's unanimous consent for that sub-amendment. So this brings us back to Mr. Gahir's proposed amendment, Lib 0303, as amended by Mr. Perkins. Are there any more discussions? I see none, and I believe we'll probably have unanimous consent on that too. So, l'amendement Lib.03 est adopté tel...
Lib 0.3 is carried.
Mr. Turnbull.
No, not on that, but I was going to seek unanimous consent to reopen Clause 4.
Just we need to adopt Clause 12 first. So shall Clause 12 carry as amended? Yes. Okay. So there I recognize Mr. Turnbull.
Yeah, maybe I'll let Mr. Gahir.
Mr. Gahir.
Thank you, Chair. So I know we had agreed a bit before we took break for the summer that we'd revisit some of the clauses as well and seek unanimous consent. So we just want to seek your guidance and the clerk's guidance as to what order you would prefer.
So based on my notes, we need unanimous consent to get back to Clause 4 and the amendments you had proposed, Lib.01 in the package, page 1.2. We need unanimous consent for the amendment that was proposed by Mr. Perkins on Clause 7. That was, I'm not sure if it was moved, but it was sent around. It was in the original package, but was not moved before we finished Clause 7. And then we'll need unanimous consent for Clause 8 for Lib.02. So that's basically the order I had in mind. So... that's fine with everyone? No? There's no unanimous consent to get back to Clause 4? Okay. Then, Mr. Perkins, if... Well, does Mr. Perkins have unanimous consent to get back to Clause 7? Look around the table.
Can I just say something on...
We'll just deal... Now I'm at Clause 7, Mr. Gahir, so we'll deal with Clause 7. I'll yield the floor back to you afterwards.
Mr. Chair and committee members, I'll refer you back to the motion. I don't mean to prolong because I know we're getting probably a little short on time, but Bill C-34, while the current legislative framework already enables the federal government to examine strategic industries, witnesses like Professor Patrick LeBlanc from the University of Ottawa have argued that letting the federal government choose to systematically review investments creates an issue in which investments are reviewed individually rather than through a sector-wide approach. According to testimony from Professor LeBlanc during the 2021 INDU report on the Investment Canada Act, not listing specific industries necessary for national security would prevent the review system from devolving into an entirely political exercise in which stakeholders representing different regions and sectors of an activity invoking national security concerns to protect their own economic interest. This would include stakeholders perhaps testifying wrongly that an asset or sector is not critical to Canada's national security in order to attract and facilitate foreign investment. So the summary of our change is that the amendment seeks to rectify this issue by responding to recommendation 4 of the 2021 INDU report, which I believe was unanimous, and many of the members here were on that committee, on the Investment Canada Act by listing specific sectors necessary to preserve Canada's national security rather than applying a systematic approach. And we've listed in that amendment high technology, healthcare, pharmaceutical, agri-food, natural resources, and energy industries. And obviously, if there are others in the committee members that feel of some industries that should be specifically listed under these terms, we'd be open to that.
Okay, thank you, Mr. Perkins. Just to be sure that we're all on the same page, the amendment you're proposing to Clause 7 is the one referenced 125-66060. Yes, Mr. Perkins? Yes. Okay, are there comments, Mr. Turnbull?
So I wanted to ask officials for some
Juste un petit moment,
comments
laissez
on
aux
this.
interprètes le temps de trouver les références, s'il vous plaît.
What happened?
Ouais.
Thank you, Mr. Turnbull.
So my understanding is that this amendment amends Section 15 and would provide the power to review SOE transactions regardless of threshold. Pardon me?
Which we already passed.
Right.
The earlier amendment.
So, and then I guess the question is what impact that has on this particular, like I think the definition of strategic Canadian industries is, might be quite challenging. And it might, you know, with sort of general coverage, and then we're specifying Canadian, strategic Canadian industries, I think this might create some challenges. So I just wanted to ask officials if they agree to speak to that.
Merci, Monsieur le Président, pour la question. So, CPC 2 that we've already, that's been adopted by the committee is specific in its application in the sense that it applies to SOEs, except for those that are from within a trade agreement country. This is opening up to a much, much broader category, and again, to some of the things that we talked about in June, to constructs that are potentially quite open to subjectivity, particularly the construct of strategic Canadian industries. Part of our goal is obviously to try and assure a certain amount of what we call high fences and small yards, where we've been very clear about that, which the Act is actually seeking to contain. And this would, in our view, probably significantly expand the potential for consideration that you'd fall yourself within that, and potentially provide risk to foreign investment, particularly those that we might not want to deter. I think it would also, yeah, I'll leave it there.
Mr. Perkins.
The list comes from some of the statements of strategic industries from the Minister of Industry, but does the U.S. not already have in law or regulation a list already of strategic industries that are automatically protected there under for review under a number of U.S. statutes, from everything from the CRTC equivalent, the federal, what's it called? It's just escaped me. The Federal Communications, they're regular.
The FCC.
No.
Oh, sorry. Which?
The U.S. Federal Telecommunications.
The FTC.
Yeah.
So the U.S. has not enshrined their list in law, and we would propose to operate a list similar to that which we've discussed before that would isolate strategic industries that would be subject to further scrutiny. But the U.S. Has not allowed for that, to allow for the dynamism of the changing nature of industry, including that which is considered strategic.
Thank you. Are there any other comments on the proposed amendment by Mr. Perkins to Clause 7? Seeing that there are none, we'll move it to a vote. Madame la Greffière.
Mr. Turnbull.
Opposed.
Mr. Sorbara,
Oppose, please.
Mr. Gahir,
Against?
Madame Lapointe. Contre, Mr. Van Bruinen,
Against.
Mr. Genereux,
For.
Mr. Perkins,
For.
Mr. Viss, Mr. Williams,
For.
Mr. Lemire,
Contre.
Mr. Massey.
Donc, l'amendement proposé.
The amendment moved by Mr. Perkins is does not carry.
So I believe you wanted to seek unanimous consent for another clause. So
For clause, do we need it for clause 8? It was
we
regarding
need it
clause-
for clause 8
So
as
it,
well. Yes.
before I ask for unanimous consent, I just want to say that, and I'm going to ask it again for clause 4 as well. This is about the consistency of the act itself. It's not about a partisan point for this side. CPC 2 is practically the same as NDP 1, which is brought by my colleague, Mr. Massey, and I'm seeking unanimous consent for clause 8 and again for clause 4 to make the act consistent with CPC 2, which is the same as NDP 1, which again was brought by my colleague, Mr. Massey. So I hope that he'll see reason here, and we can make the act itself, which is going to affect Canadians and businesses in Canada, consistent.
So right now, just you're asking it for which one?
8.
For
Clause 8.
Okay, do we have unanimous consent to revisit clause 8? Nope. Okay, then that's it. Et après, il nous reste just 1 second. So this, we still have a few routine proceedings to do. So, est-ce que le titre subsidiaire est adopté? Oui. Le titre est-il adopté? Oui. Le projet de loi tel que modifié est-il adopté?
The bill as amended, is it carry? Yes. Does the committee allow the chair to report to the House and to print the bill as amended to be used at the report step?
Je vais présumer que c'est vos cours de français là, qui font défaut, et que c'était dans le fond un oui. Donc,
Yes. Thank you. Thank you, everyone. This concludes our study of C34. Finally,
being with us, thanks to the Conservatives who allowed us to bring it back to start this session, because we could have ended it in the spring. That,
Are we out of time?
Mr. Perkins.
Are we out of time for the
Yes, no,
motions?
we're not out of time. We still have half an hour. So I'll just briefly.
I'd just like to thank the officials who sat through a lot of stuff on this bill as well and have been very helpful on the process. Thank you very much.
Yes, indeed. Thank you very much, and I'm sure we'll see you around in the not too distant future. So thanks for that.
Imagine on what.
I will also thank the legislative clerks who have been very helpful, and at times it can be a bit confusing as we deal through all these amendments. S'il n'y a pas d'autres commentaires, je vais.
if there are no other comments, I will briefly suspend and we'll come back to the motions. Mr. Lemire, I'd like to thank the interpreters, and thank you to the interpreters. I will suspend for 1 minute. Thank you.
And the committee is now. We will resume with the notice of motions, the motions that were presented earlier by Mr. Perkins ainsi que par Monsieur Lemire. Je vois que Monsieur Massé aimerait intervenir.
I see that Mr. Massé would like to speak as well. Do you have motions as well for study projects? No?
Okay. On a what?
On Mr. Perkins' motion.
On Mr. Perkins' motion? Yeah. Okay, okay. So, sorry, I thought you had a motion you wanted to present. So we're on Mr. Perkins' first motion regarding the PBO report. And just before we start discussion, I would just suggest maybe, because the clerk was telling me that usually before the committee orders, we request. And in the wording, if there is consent to just modify the wording to have a request instead of order. And then, so we're on that motion. I'll yield the floor to Mr. Massé.
Thank you, Mr. Chair, and real quick, I support this motion, the first one. I think the second one is probably maybe a little bit premature, and we could revisit that perhaps in the future, because I'd like to see what the first one actually kind of comes towards, and then go. And then the other one, I do have an amendment. Like, I mean, we could have redacted copy, but just like that almost would be a process for a decision also. So I don't want to suggest that we have to have information redacted. Whereas in the United States, it's very clear their process for investment was taking place. So for me, I just prefer to get this first one done and get it going, and then have our steering committee, because we have another guest, and then decide about what our order is in place. So I'll support the first one. The second one, I'd prefer to wait on that in terms of how we get our house in order. And thank you to the
Duly
mover of
noted.
the
Just
motion.
to maybe rein in the debate, but I think it's worthwhile that you mention it so that we know where your mind is at. But we're dealing with the first one. Hopefully, we can keep the debate on the first one, then we'll move to the one Mr. Viss has proposed on the contracts. So, Mr. Perkins, and then Mr. Viss.
I appreciate the clerk's suggestion about request. I think this is straightforward, so I don't think we need to have a lot of debate or discussion. The PBO put out his report recently, and I think it would be appropriate to have him come here to have a discussion about that report, since it's on obviously a $28 to $30 billion worth of contracts that the Minister of Industry is responsible for. And it's a valuable report to be able to question him. I'm not sure where else he would go other than here.
Okay. Mr. Turnbull.
I don't see a problem with this one. I think it's would be. I think we'd be supportive of it. So I think it seems pretty reasonable.
And just before we move to a vote, this is basically to inform the committee on what we want to study as a committee, what we decide that we want to pursue, knowing full well that C27 takes precedence, and that's what we're going to be dealing with in the next few weeks. So we can. Do we need to vote on the first motion? I seem to sense that there's a consensus on the motion proposed by Mr. Perkins. Monsieur Lemire, vous m'avez l'air dubitatif.
Je pose la question à savoir.
I'm wondering when the PBO could come if C27 brings us to have several meetings, because the witness list is quite long. To have him come later in the fall or the winter, would that be the responsible thing to do given the circumstances? Because it's just one, I think we can find a time. Well, I think with the subcommittee, we'll be able to look at this, and it's always practical to have a backup meeting. If, for example, the clerk isn't able to find witnesses, or if they cancel and we have an extra hour or 2 hours for a meeting, that we won't lose the time. And normally the PBO is quite flexible for these types of meetings. Thank you. Mr. Perkins.
Just a suggestion for the committee in that I think we're all assuming we start C27 next meeting. Tuesday, sorry. Tuesday. Hard to get it. On Tuesday. We haven't obviously gone through or been able to get witnesses yet, I don't believe, for Thursday, so perhaps Thursday might be an opportunity for the PBO. Oh, the Privacy Commissioner, right.
Okay, so just to dispose of that first motion, I see there's consensus, so it's adopted by the committee. So on the second motion by Mr. Viss, I recognize you, Mr. Viss.
What's very important to note here, it states very clearly, redacted copy. We understand commercial sensitivities. I will note the minister has basically said everything in that contract publicly already. So I think it would be beneficial to all committee members if we're going to have a discussion with the PBO on the government subsidy, that we have those 4 contracts available to us at the same time. It's just about being able to do our job as best as we can. We know the dollar amount. We just need the details in front of us. Thank you.
I have Mr. Turnbull and then Mr. Perkins.
Could I just clarify
Yes, Mr. Perkins.
I just want to clarify on the redacted. The reference in redacted is we saw, when committee members had access to the contract, we saw a redacted version. So that's the version I'm talking about, because Volkswagen redacted certain parts of it already before we saw it. Yeah. So it's that version. It's not a further redacted version beyond what was shown to committee members. It's the one that was shown to committee members.
Mr. Turnbull.
Just wanted to say that I sort of share the sentiments made by Brian Mass, my colleague, that I'd want to sort of consider that there seems to be a little bit of a, I realize it's a redacted copy you're asking to be released. I know that members had, based on their parliamentary privilege, the ability to review that document that was redacted already. But there's also, a portion of this that says no speaking restrictions be placed on committee members. So there is some considerations here as to whether there's sensitive details of that contract. And there was very few redactions in it, as I understand. I haven't reviewed it myself. But I think we should take some more time to consider this, and perhaps we could bring it up in subcommittee, which I understand I'll be on, so maybe we can talk it through there and just make sure that we consider every aspect of this.
Mr. Massey.
Mr. Chair, and I think the motion comes from a good place. So I don't think, I think Mr. Viss it comes from a good place. My concern right now is I'd like to see what we have going forward, is that the entire debacle costs us jobs, and the plant in Windsor was actually even shut down for a while, and there still is a lot of angst and anxiety and issues that I don't want to stir up unnecessarily without a real plan for a reason for it. I'm not even sure we need, at some point, redaction entirely of it. For the auto policy that I've been pushing for on the Hill up here is actually similar to other countries where there's actually measurables for jobs and so forth, and getting a redacted document is not necessarily where I want to be at the end of the day. So I'm not necessarily opposed to eventually going down this road. I think that is a possibility, but I think the motion that we have before it is a strong, good motion, and we can do our work on it. And I chose not to get one of those briefings because also, too, is I didn't want to get myself inadvertently in a conflict of interest on the file and not be able to represent my constituents by getting an in-camera briefing on something. And so I have a lot of reservations about supporting it at this moment in time. But I think it does come from a good place, again, from the member. I don't think it's mischief. I don't think it's unreasonable. But at the same time, it doesn't, for me, make a better process right now. So I won't support it at the moment.
Thank you, Brian. Mr. Perkins.
Just in terms of time, we're not looking, obviously, for hearings or anything. We're just talking about the release of the document that we've already seen. And that it be made. I don't think it should cause any angst since it's the signed contract and we're not holding hearings on it. And it is, Volkswagen was asked before we saw it what they didn't want to show us for commercially sensitive reasons, and they exempted 3 elements of the contract. So by inference, that means everything else they were comfortable with from a commercial perspective or commercially sensitive perspective. So I don't see any reason for there not to be transparency to support the government's position on these record-setting production contracts of $30 billion, where it's been all focused in one province. There hasn't been any similar types of production subsidies. By the way, production subsidies is not something we normally do. Production subsidies in any other province, and that we actually see what it is that's claimed, because the minister has made claims that the PBO disputes already in terms of the payback time. So the contract could help provide some certainty for the public out there that there isn't other things in the contract that are inconsistent or are consistent with what the minister has said publicly about them.
Okay, Mr. Turnbull.
Well, I'm sort of hearing pretty strong sentiments from others that we're not going to perhaps get there to a vote today. So perhaps we want to talk about this in subcommittee and determine. I'm kind of uncomfortable with this without considering it in more detail. I think I think we need to think about how this could sort of prejudice other deals and relationships in the future. I think we need to consider some of the aspects of how it's worded and the no speaking restrictions part. I think what we're saying is that something that we've reviewed in camera as part of our parliamentary privilege would be made public, and I think we need to consider, very strongly consider, what the ramifications or unintended consequences of that may be. So I feel like we may be able to achieve, a path forward on this, but I think we need a little bit more time. So if members would agree to defer this to the subcommittee, I think we could talk that through in a reasonable manner and hopefully find a path forward.
Mr. Viss.
Yeah, I'll just respectfully point out, and I don't know this issue as well as Brian, but as soon as Stellantis found out about the Volkswagen deal, the first thing they did in terms of being, it doesn't matter what's in the contract. They said we're not going to go forward anymore unless we get more money from the government of Canada. So the number one concern that people had when the Volkswagen contract was signed was this is going to lead to a slippery slope where any major investment in Canada now will require major subsidies from the government of Canada because that's the precedent that's been set. Shortly thereafter, that came to fruition with the Stellantis contract. So everyone already knows the key aspects of the deal outlined by the minister, that for the first time in history of Canada, maybe one of the first times in the history of Canada, we're going to be subsidizing not only the production or the creation of a factory, but we're going to pay Volkswagen, one of the only companies in the history of Canada to break our Environmental Protection Act. We're going to pay them billions of dollars to produce a product that they then get to sell for a profit for up to 10 years. That is a fact. That is the basis of the contract. So there's the commercially sensitive nature came out a long time ago. I just want to have a copy of those contracts so when the PBO comes, we can challenge and look in detail at the costing estimates on a year-by-year basis in terms of what the government of Canada is going to be giving Volkswagen to produce a battery that they're going to be able to sell for additional profit. Thank you.
Okay, colleagues, I see no more interventions, and there's a motion on the floor, so technically it should be voted on unless there are more comments or debate. But there are suggestions by some to just...
That's a fair point. We can delay the vote if you'd like.
Parfait. Okay.
En ce sens-là, j'allais aussi.
Okay, perfect. So then it shall be discussed between the parties, and we keep it ongoing, Mr. Viss. And Monsieur Lemire, on va revenir à votre motion quand on l'aura reçue.
Mr. Lemire, we'll come back to your motion when we will have received a written copy. I didn't see it. Unless you want to discuss it right away. No, I just wanted to table it because it goes with what will be debated at the House. Yes. Okay, so over the next 2 months. Yes, of course, but I thought it was important to table it. It's in everyone's interest to modernize this law, and it's really important in the wireless context. Thank you. This ends our meetings. We're on budget and on time. We finished C34, and that's great.
Have a great evening. See you next week. Meeting adjourned.